Ron, that document is nothing. It's not even notarized. You know, if you die and you don't have a real will, most of what you own will go to the government.
Where's this lawyer you speak of?
Okay, well, no. It's hilarious, and he gets an A+ for playing off of Ron's libertarianism, but no. Someone who dies without a will, all their belongings do not automatically go to the government. Hey everyone. One of my favorite examples of estate planning in popular media comes from Parks and Recreation in an episode from season 6 titled Gin It Up. Now, if you are familiar with Parks and Recreation, and particularly the character Ron Swanson, some background context will be important to understanding the scene here. Ron is
A libertarian.
who does not want to see his sweet town of Pawnee, Indiana, turned into a
Socialist hellscape.
despite himself being a government employee. When town meetings turn to topics like cutting the local budget, Ron has a unique take.
With current and projected deficits, we need to cut expenditures by 32%.
Let's make it an even 40.
Oh, that's not necessary.
Slash it. Slash it.
And sometimes his disdain for government even gets a little, weird.
I am an official member of a task force dedicated to slashing the city budget. Just saying that gave me a semi.
And if you stop Ron and ask for a permit, you get a response like this.
Not to worry. I have a permit.
This just says I can do what I want.
Okay, so I think you've got it, right? Ron is not a fan of the government, and it's important to understand that as we go into our scene today. So, without further ado,
Whoa, I am pretty sure you shouldn't have a weapon at work.
Literally everything is a weapon, son. That folder in my hands is far deadlier than this bow in yours.
Oh, that's probably true. So Leslie and I just finished putting together our will, and she wants you to be the witness. You mind signing it?
now it is important to note that having witnesses to a will is an important part of the process. In the US, witnessing laws do vary from one state to another, but generally speaking, you want witnesses. After someone dies, their estate gets processed by a probate court, generally a loved one, where the person who is named the executor in the will is going to have the task of finding the will and bringing it to court. At this point, the court has the task of determining whether the will itself is authentic. Since you won't be around to attest to the authenticity of your own will, the primary way the court can do that is to call witnesses and have them confirm that you signed the document. You were of sound mind at the time, and there was no coercion, manipulation, or other shenanigans going on. If you don't have witnesses, it's obviously that much harder for the court to determine if your will is authentic.
That's your will? You need that many pages to say give my stuff to my wife?
It's a complicated legal document.
Doesn't have to be. I've had the same will since I was 8 years old.
Upon my death, all of my belongings shall transfer to the man or animal who has killed me. What are these weird symbols?
The man who kills me will know.
Okay. Wow. This is great. Now, there's so much nonsense here, but there is something I want to draw attention to. Handwritten wills are a real thing. And just because a will is handwritten, or even unwitnessed, doesn't automatically mean that it's invalid. A non-witnessed handwritten will is actually what's known as a holographic will. Certainly, you want to avoid handwritten wills if possible, but there are some cases where perhaps you can't have witnesses and perhaps you have to write it by hand. Imagine someone has fallen and hurt themselves in the wilderness. If they think there's little chance they'll be rescued and they don't have a will, they might resort to trying to write something that might be found when their body is discovered. Or there's a scene in Buried where Ryan Reynolds is being buried alive and dictates a will on his camera.
This video will serve as my last will and testament.
Now, would these types of wills stand up in court? It depends a lot on individual circumstances and the rules of a given jurisdiction. But the main point here is just because a will is handwritten does not automatically mean it's invalid. Now, Ron's crazy symbols, yeah, I doubt those are going anywhere in court.
Okay, you should really have a will that's more than one sentence long. You have a wife and kids now. I could introduce you to our lawyer.
The three most useless jobs in the world are, in order, lawyer, congressman, and doctor. Pass.
Oh, yeah, not going to touch that one.
Ron, that document is nothing. It's not even notarized. You know, if you die and you don't have a real will, most of what you own will go to the government.
Where's this lawyer you speak of?
Okay, well, no. It's hilarious, and he gets an A+ for playing off of Ron's libertarianism, but no. Someone who dies without a will, all their belongings do not automatically go to the government. Unfortunately, The reality is that a lot of people don't prepare estate documents like they should. As a result, every state has formal rules for dealing with how to distribute property of someone who did die without a will. Dying without a will is actually formally known as dying intestate, and the rules of intestacy dictate what will happen in this situation. Generally speaking, what the state is going to do is be looking for somebody's next of kin or their line of succession. Commonly, this might be a spouse, children, even grandchildren if a child died before their parent. States do vary in whether they give preference to a spouse over adult children. To give an example, the state of New York provides a table to help understand how their rules of intestacy work. As you can see, if a spouse dies and has no children, then the spouse inherits everything. However, if a spouse dies and has children, then the first $50,000 goes to the spouse, and the remainder is split between the children and the spouse equally. If someone doesn't have a spouse or any children, then the state would look for parents and then siblings to inherit any assets. It's only in a case where the state cannot find any family that any assets would be going to New York State. It is worth noting here that these rules of intestacy only apply to assets that would have passed through someone's will if they had one. There are many common types of assets that wouldn't pass through someone's will. For instance, if you have life insurance and there's a beneficiary named, those life insurance proceeds would pass to that beneficiary regardless of what your will says. The same applies for beneficiaries of 401k accounts, 403b accounts, IRAs, Roth IRAs, and other employer-sponsored retirement accounts. Someone may also have a bank account or a taxable brokerage account with transfer on death instructions that effectively work the same as a beneficiary designation and would pass outside of someone's will. But I really want to emphasize here that these types of beneficiary designations will even override a will. If someone's will says, give my assets to my children, but their beneficiary designation on their retirement account is their brother, then if they pass, those assets are going to their brother and not their children. This can get quite complex when we're talking about divorce and remarriage. The Egelhoff is a famous case that addressed some of these complexities and went all the way up to the Supreme Court. In short, husband and wife got divorced, and the husband was killed a couple of months later in a car accident. He never updated his beneficiary designations, so his ex-wife was still listed, and that's who the plan assets were paid out to. His children sued, however, because the state where Mr. Egelhoff lived, they had a law that said that an ex-spouse's status as a beneficiary is immediately revoked upon divorce, and therefore their mother, the children argued, should have lost her status as the beneficiary, and the assets should have gone to them. Where this gets even more complicated is that the plan in question was a retirement plan governed at the federal level by the Employment Retirement Income Security Act, or better known as ERISA, which includes common employer plans like 401ks and 403bs. Now, ERISA states that assets should be paid to the listed beneficiary and does not have any stipulations regarding divorce. Furthermore, ERISA states that ERISA supersedes state laws in the event that there's a conflict. So in this case, federal law said that the assets should go to the ex-wife, while state law said that they should not. But the Supreme Court ruled that federal law controls in this case, and therefore assets would go to the ex-wife. Now, if you want one more wrinkle to make this all more complicated, ERISA applies to accounts like 401ks, but it does not apply to accounts like IRAs. So it's not clear we would have the same result if the account in question had been rolled into an IRA. But the real practical takeaway here is to always update beneficiary designations. Individuals should check these regularly, and they should make sure they reflect their current wishes, because they will generally override whatever's in someone's will. Okay, now back to Ron's situation specifically. We talked about New York law, but of course, Parks and Rec take place in Pawnee, Indiana, and not New York. So New York laws wouldn't apply to Ron. If we look at the table here that I got from Nolo, we can see that Indiana has a fairly similar set of rules as New York. If someone has a spouse and kids, then assets that pass via their will get split 50-50. Interestingly, in Indiana, if somebody's married but doesn't have children, then 25% of that married individual's estate would still go to their parents instead of entirely to the surviving spouse. Personally, I think these laws, like New York and Indiana's laws that don't give greater preference to a surviving spouse, are bad laws. I think these laws are far too favorable to adult children, and pretty much everything should be going to a surviving spouse as a default. There's something known as the Uniform Probate Code, which is a consistent set of rules that states could adopt if they would like to. And in this code, all assets would go to a surviving spouse first. However, only a limited number of states have fully adopted these rules, so rules in this area can vary a lot from one state to another. But the practical takeaway here is to have estate documents in place so that you don't have to rely on these rules. Now, I want to go back to another thing Ben said in the last video.
Ron, that document is nothing. It's not even notarized.
Interesting question here. Does a will need to be notarized? Again, the answer is no. Now, it is generally a good thing to have a will notarized, and there are often some benefits to doing so. For instance, I'm in the state of Maine, and in Maine, if a will is notarized and meets other requirements, it can be what's referred to as self-proving, meaning that the legitimacy of the document can be determined by the court without needing to call witnesses. And this can significantly speed up the probate process and be less hassle for your witnesses as well. Indiana has similar rules around notarizing wills for those to be self-proving. So while it's not required for Ron's will to be notarized, it might still be in the benefit of his heirs if he did have a notarized will. Now let's watch more.
All right, just let me do the talking here, okay? I mean, he's a lawyer, I'm an accountant, we speak the same language. I mean, obviously, accountants are a little more bad boy, but there's a respect there.
When will this be over?
I can't speak to the specific dynamics between accountants and attorneys, but it's definitely true that there's always some interesting status dynamics between different types of professionals.
Hey, Trevor, I've been talking to Ron about estate planning, and he is here to do some goodwill hunting. So he has to draw up a new will, so...
Yes, I understand, Mr. Wyatt. Thank you. As I've said before, I just don't like puns.
Oh, well, my accountant friends seem to enjoy them.
Mr. Swanson, let's begin by filling out this form listing your assets and liabilities.
Nice try. I'm not telling you how much money I have, where it's hidden, or which precious metals and or gemstones it may or may not take the form of.
While Ron is obviously being a little over the top here with his refusal to share information, this is actually a challenge all sorts of professionals deal with. Probably a little bit more unusual for somebody who's working with an estate planning attorney to not be transparent about their estate. But it's clear Ron doesn't really want to be there in the first place. For the estate planner to actually do his job, in this case, he's obviously going to need information to understand how the different types of property will transfer, how property is titled, and other important considerations. As a general note, if you are working with professionals, you do want to be transparent. Often, you don't know what you don't know. And it's those types of circumstances that can really hurt you if you didn't disclose everything.
If you don't give me the information I need, there's nothing I can do.
Oh, come on, Trevor. Where there's a will, there's a way.
I'm going to say this one last time, Wyatt. Check the accountant crap at the door.
Yes, sir, I will. Unintentional.
Okay, again, I can't speak to these dynamics, but it's still funny.
I don't even need an exact number. Just ballpark it. That's all I need to get started.
Or I'm sure the state government would love to use your money to hire more bureaucrats, maybe build a library.
Fine. A ballpark figure.
So here it's actually sort of interesting the attorney didn't correct Ben. I get it, this is for TV, it's meant to be entertaining, but I would hope most attorneys aren't going to let someone be pressured into divulging information under a false belief about what would happen in the event of their death.
Fine. A ballpark figure.
Thank you. God. Holy. Is this a joke?
Another word for jokes is lies. I do not lie, therefore I do not joke.
That's great. We don't know the number here, but to me, Ron's surprise wealth fits pretty well with the whole millionaire next door type phenomena. As an advisor, you get lots of firsthand experience seeing the difference between how someone portrays themselves and what the reality is. I've met with dentists who've rolled up to the meeting in $100,000 cars and are absolutely broke. If you're just looking at them, you'd think they were a dentist, they must be really well off, but that's not necessarily the case. On the other end of the spectrum, I recall one particular meeting with a farmer in Iowa at a McDonald's of all places. He was so wealthy, you wouldn't believe it. But from his appearance, calloused hands, dirty blue jeans, even asking to meet at a McDonald's, you would never have guessed it. I've also seen this a lot in young followers of Dave Ramsey. When people get on those baby steps, they work them hard, they develop good habits. It's amazing how fast they can make tremendous progress. I see memes all the time about how homeownership is impossible for millennials. You might be surprised how many people in their late 20s, early 30s are out in the world living mortgage-free. Again, though, these people are usually not driving Teslas, and you wouldn't guess that there was anything unusual about their wealth.
Mr. Swanson, an estate of this size means that your children would never have to work a day in their lives. This is going to take some time. Trusts need to be drawn, tax shelters.
This is actually illustrating an interesting phenomena and something that often bothers me when I'm helping clients go through the financial planning process. The attorney here has looked at something quantitative and jumped to all sorts of conclusions very quickly about the need for trusts and tax shelters. However, we've yet to hear anything about Ron's actual goals and what he's trying to accomplish. Now, again, I get it. This is for TV. It needs to be entertaining. But this does happen in the real world all the time. And I think we're particularly prone to it when we have some sort of specialized knowledge in a certain area. So specialists in particular, we can get drawn into excitement over some unique solution we're aware of while losing sight of whether that actually fits what the client is trying to accomplish. I can think of one business owner in particular who was sold a very complex business structure. It had multiple entities, paying other entities, and that was recommended by an accountant for tax purposes. Now, it's very possible that there was some legitimate basis for the structure. Honestly, it was so complex, I personally was having a hard time following it. But what was more important is that it was actually making her life miserable. She liked being a solo business owner and the simplicity that came with that. But with her new structure, she started running into issues around missed tax filings, payroll issues, and all sorts of other complexities that got added to her life. If the accountant had better understood what type of business she wanted to run and how she wanted to live her life, I don't think there's any way the minor tax benefits would have justified the headaches and stress the strategy introduced. I've had to try and pause myself when I see a situation where perhaps a solo 401k is a really good solution for a business owner. But when we stop and talk about the complexities that come with a solo 401k versus perhaps a more simplified plan like a SEP IRA, it's entirely possible that the SEP IRA is the better solution despite the tax benefits. But the main point here is to advocate for yourself. If you find yourself in a situation where things are getting pulled in a technical direction that might not actually fulfill your goals, never forget that it's your money and it's okay to advocate for yourself.
That's enough. I do not need some drawn-out legal expedition to tell me what I knew when I was 8. Here's my original will. Do whatever lawyer nonsense you have to make it official, and I will sign it. Good day.
Okay, well, I should have figured that Ron Swanson would do an okay job standing up for himself. Very unclear here how the attorney is possibly going to reconcile the complex trust and tax shelters with Ron's bizarre will, but I guess we'll see.
Wait, what are all these symbols?
I was right not to be threatened by you.
Oh my gosh, I love Ron. He's just the best.
We need to talk.
That has never been true.
I think I know what's happening. Thinking about how to divide up your possessions for when you die, it's tough confronting your own mortality, and I think it's got you spinning a little bit. All right?
Wow. I had not considered that. Yes, I think that maybe you are onto something.
Now, avoiding estate planning due to the discomfort of dealing with mortality is a very real thing. Some psychologists will refer to this as mortality salience, and there's all sorts of interesting ways that it does influence our behavior. Some have even argued that mortality salience is relevant to things like the use of financial products like annuities. Thinking of estate planning specifically, though, it's also something that just never feels like a high priority. No one expects to get hit by the bus. It always feels like you can put it off another day, but you really don't want to do that. The mess you can leave behind for your loved ones by not getting your affairs in order is significant. As not fun as estate planning is, it really is important.
Yeah, just know that it's perfectly healthy to be thinking about... Oh, you're joking.
Yes, son, I am.
Oh, leave it to Ron to just spoil my previous point. In any case, even if Ron doesn't get uncomfortable dealing with death, many of us mere mortals do.
First joke ever. Don't care for it. Death does not scare me. What I am worried about is spoiling my children. I don't want them to be the kind of people who never work, live off their trust funds, who buy their wooden furniture. I will leave my children $50 apiece for the cab home from my funeral and a steak dinner. End of discussion.
All right, so Ron spoiled my previous point, but then still makes a good point himself. Concerns about spoiling children are very real. There's also concerns about children who may not be fit to inherit funds, or at least without the protection of a trust or some other sort of protection in place to ensure that assets don't do more harm than good. Dealing with children with substance abuse issues is a common concern in this area. Or more to Ron's point here, he simply just doesn't want his children to feel like they don't have to work. And I think that's a very real and valid concern. Maybe you've seen a meme like this one before, claiming that there's a cycle of hard times creating strong men creating good times creating weak men, and weak men creating hard times. Now, I think this is a bit oversimplified in meme form and may not apply 100% here, but there's still definitely truth to the fact that our circumstances or the environment that we're in definitely does influence who we become. Now, I don't recall the exact source, but I know I've read about famous entrepreneurs talking about the advantages of being an immigrant entrepreneur, and particularly those that come from nations that are substantially less wealthy than the US. And that can be an advantage because those immigrant entrepreneurs that come over and aren't acclimated to the incredibly high material standards that we have in the US can just have a real leg up. And couch surfing at a friend's crowded apartment in the US might still look luxurious compared to living conditions in some parts of the world. And no matter what you have materially, when you approach it with sort of that gratitude and appreciation, and even lack of fear of what failure might look like, that can really put you on a totally different trajectory in life. So I think Ron and parents in general are absolutely right to be concerned about how much is too much to give to children. A good estate plan should be able to accommodate a parent's wishes. Now, I do think Ron is probably being a little too narrow-minded here and thinking through how his wealth could be used to benefit his children. You don't want wealth to spoil children, but it's also true that it can open up doors and create opportunities. Rather than just giving his kids $50 gift cards and cab fare home, I think perhaps some creative trust planning around how funds could be used, or maybe leaving part of his estate to children and the rest to charity, might be able to provide more of a win-win solution here. But again, it's Ron's wishes, and ultimately, that's what matters.
Okay. I mean, look, it doesn't matter how much money you leave your kids. What matters is that you teach them the right values. But if something horrible happens and you want your kids to be left alone with no safety net just so they can learn some kind of weird lesson, then by all means, leave your fortune to the wild boar who gores you to death.
And never lose to a boar.
So it seems like Ben might have gotten through to Ron a little bit here. Zero safety net is probably not what's best for Ron's children, but Ron still has a point in wanting to be careful about how his assets are transferred to children.
Benjamin, after thinking about what you said, I've decided to leave each of my children 5% of my fortune.
Wow, 5 whole percent. So I guess you are going to teach them a lesson. Oh my God, that's 5%?
So there we go. Ben did get through to Ron. Ron ended up giving some safety net to his children, but not all of his wealth. Sounds like 5% is an incredibly large sum still here, so still not a trivial amount of money for his children, and probably particularly true if they're like everyone else and not expecting that Ron has much to give. Now, as I'm watching this, I'm actually wondering if Ron has a taxable estate. Watching this in 2022, our federal unified estate and gift tax exemption in the US is $12.06 million per person, which allows a couple to transfer up to $24.12 million estate or gift tax free. Granted, there's also annual gift exclusions that are allowed up to a certain threshold. In 2022, that amount is $16,000 per individual, and through a strategy known as gift splitting, a married couple could effectively transfer up to $64,000 to a married child and their spouse in 1 year without using up any of their gift tax exemption. Now, if someone did gift more than that and had to use up some of their exemption, it's generally not a big deal. A tax form just needs to be filed, and then that individual who gifted does use up some of their lifetime exemption. Also important to note here that gifting does not apply between spouses.
That is a lot of money. Wait, is this a joke?
It is not a joke. Not that an accountant would know the difference.
Also, if something should happen to Diane and me, we decided that the kids should go to the most important people in our lives.
Ron, I'm incredibly flattered.
Ralph Pietkowski and his wife, Helen. He's the maitre d' at Mulligan's Steakhouse, and he knows me better than anyone.
Oh, that's too good. Ron would leave his children to the maitre d' at his favorite steakhouse.
However, if they are not able to do it, which seems likely as they're in their 90s, you and Leslie are choice number 2.
I'm honored.
Have to say, I don't think it's very wise to designate a couple in their 90s as the primary guardians for children, but this does raise an important issue. Estate planning is about far more than just the transfer of assets. In fact, for many young people whose primary assets to transfer would primarily be life insurance proceeds, 401k, IRA, or other similar types of retirement accounts, the will might not actually be doing much in terms of transferring assets. However, the will can be incredibly important when it comes to things like appointing guardians for minor children. Many people are under the impression that just because they have godparents for their children, they don't need to name guardians, but this is generally not the case. It may be the case that a couple wants the child's godparents to also be their guardians, but a will is the legal way to make that declaration. And this is one of the most commonly overlooked benefits of estate planning for young families. A full set of estate documents will generally also include other beneficial documents, such as powers of attorney, living will, and a HIPAA authorization. Powers of attorney appoint someone to act on your behalf for medical or financial purposes. Many people will choose to have springing powers of attorney, which means that essentially the documents are all in place, but the powers to act on someone's behalf don't actually start or spring into effect until certain conditions are met, such as incapacity. This can make a stressful situation a bit less stressful and also helps ensure that you're identifying individuals that you want to make decisions on your behalf. Alternatively, powers of attorney could go into effect immediately, and someone could make decisions on another person's behalf as soon as those documents are put into place. If powers of attorney go into effect immediately, they can also be what's known as durable, meaning that they would stay in effect if the individual became incapacitated, or non-durable, meaning that the power of attorney would essentially be revoked if the individual lost capacity. Non-durable powers of attorney are more commonly given to someone like a financial advisor who might be managing an account on behalf of a client, whereas durable or springing powers of attorney are more common in estate planning. The next document is a living will. This can be confusing sounding because a will and a living will sound pretty similar. However, you can think of a living will as essentially a set of instructions for the types of medical treatments you would like if you're incapacitated. And lastly, a HIPAA authorization authorizes certain individuals to be able to receive medical information on your behalf in the event that you're incapacitated. When I personally completed my estate documents, my attorney suggested that my wife and I take a copy of our documents and put them on file with our local hospital. That way, if we were ever traveling, something happened, we could tell them to get in touch with our local hospital, and they could assist with getting those documents over to them. And another note on estate documents, many people realize estate documents are important documents, and they might choose to put them somewhere like a safe deposit box. However, this may not be the best place to put your documents, or at least not your only copy of your documents, since your heirs would generally not have access to your safe deposit box until the estate is being processed. For that reason, you might want to keep your documents with an attorney that drafted them. You may want to file them with a local probate court, if that's an option. Just put them somewhere safe in your home, or even with your executor, so that they would have them handy in the event that the documents are needed. And if you take nothing else from this video, please understand how important it is to get basic estate documents in place. My primary recommendation is to go to a competent local estate planning attorney. Estate planning is important, and there are just some expenses in life you don't want to skimp on. That said, if estate documents truly are unaffordable, there are some other options. If you're someone who lives in a state that has published a statutory will that residents can use, you may be able to find that will online, and you simply might need to fill it in and sign it. I'm in Maine, so my state offers this type of statutory will online. That said, a will is not an entire estate plan, and there are other documents mentioned previously that would be good to have in place as well. The final option that we're increasingly seeing more and more of is online document preparation services. There are companies like Trust and Will, Nolo, LegalZoom, and others that offer packages for completing different types of estate documents. If you have a very basic situation, these providers might be something to look into. And I'm very confident that it would at least be better than a handwritten note with symbols for the man or animal who kills you. Now that said, I do want to caution that if there are any complexities, children with special needs, limited capacity of those signing documents, disinheriting a spouse or a child, anything more complex like those types of situations, you almost certainly want to be working with an attorney. And now to wrap things up, if I pull out my grading pen and give Parks and Rec some grades, in terms of estate planning accuracy, I'm going to have to give him an F. While it was comical and it set the scene up perfectly, Ben was not correct in telling Ron that all of his assets would go to the government without a will. In terms of entertainment value, I'm going to give them an A+. This is by far my favorite depiction of estate planning in popular media, and I've used it in class for some time now. And finally, I also want to give Parks and Rec a grade on one more dimension, which is realism. Now, this is the category I was originally going to give them an F in, but then I realized I'm not sure if that's quite right. You see, although Ben's guidance was not correct, it's actually incredibly accurate to be portraying a non-professional giving incorrect guidance to a friend or family member. Some of the interactions with the attorney were probably not quite realistic, so I'm docking them down a bit to a B+. But I do want to make this final point that you always want to be going to a qualified professional to get advice. In fact, I'm not an attorney, so you should even be skeptical of everything I've said here. Of course, nothing here is legal advice, and it's just meant to be educational, but please seek competent guidance in all areas of your finances and realize that, generally speaking, although they love you very much, your friends and family aren't experts on financial matters. So what do you guys think of this video? Should I do more of this style? I thought it was fun to dive deep into this, but leave a comment below. Let me know what you think.